I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are on number 172 on our compilation list. We will be in 3 different judges' courtrooms. And for this compilation, we will be in the state of Michigan for all 3 judges. Before I give you the rundown on these courtrooms, just know that there will be chapters added to this compilation for your convenience. The commentary from these proceedings being previously aired will also remain in this compilation. Now, let me give you the rundown on the judges. Oh, before I do, don't forget to like, comment, share, and subscribe. Listen, the YouTube algorithm has been showing us favor, being that you guys have been more active, and we're just trying to get a better schedule going with these videos because it's a lot when it comes to the YouTube algorithm and how you handle things. So shout out to you guys, and we're trying to play our part as well so that these videos can be shared with more people. Now, the 3 different judges' courtrooms we will be in on today. First, we will be in the courtroom of Judge Mark Slavens. And for this particular proceeding, it's going to be a sovereign citizen. And it's a reason why I'm telling you the sovereign citizen's name by Tenia Tubbs. Her name is Tenia Tubbs. And if you guys have been following this channel for a while, you know who Miss Tubbs is. And just to give you a little backstory on these 2 proceedings that I'm going to share her second and third proceeding. I'll put a link to her first proceeding if you want to see that. But after all this was said and done, I had got a comment or a few comments on a couple of these videos, and you can probably go back and backtrack in the comment section. I believe it was on the original video where a young lady was claiming to be her. And long story short, when I did all of the research on what the young lady was saying, it was absolutely Miss Tubbs. She actually wrote a book. I can't remember what the title was. I went and looked it up, and it was definitely her. But it just goes to show you that sometimes some of these different sovereign citizens and people with these arguments in court, in the court rooms, are watching some of these videos, and sometimes they'll say something in the comment section, and she had a few things to say. I never said anything negative about her, just pretty much shared her proceedings and what it is that she had to say in her proceedings, like I'm doing now. But I just pretty much left it at that. But yeah, you can definitely go in one of these comment sections and find that. Sorry for the long story, but just wanted to give you a little background on the story. But she was very popular on the channel with all 3 of her proceedings. So I'm sure with this compilation, you guys are going to really have a lot to say about her second and third proceeding. Next, we will be in the courtroom of Judge Marlena Taylor. And last but not least, we will be in the courtroom of Judge Donald Coleman. Once again, these 3 different courtrooms are all in the state of Michigan. And now let me be quiet and get out of the way, and let's jump into 172.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
Good morning, Judge Deanne Patillo, P82378 on behalf of Ms. Tenia Tubbs.
Ms. Tubbs, can you unmute and state your name for the record, please? And is Ms. Patillo standby counsel? Is that what this is?
Yes, Your Honor.
Okay. Ms. Tubbs, if you can state your name for the record, please.
Grand Rising. I asked the Holy Spirit to come in here and touch this courtroom today, and I welcome the Holy Spirit. I am Tenia Nicole Tubbs, the beneficiary.
Okay. And Ms. Patilla is being appointed as your standby counsel, Ms. Tubbs, all right?
No, sir, I did not ask for that. But if I'm being forced, then I'm being forced in direct coercion.
All right. Well, I'm not forcing you, but she's going to help in case you need anything. You don't ever have to use her, but if you want any questions on anything, she's there to help you, okay? You're gonna represent yourself, but if you have any questions, you can ask her, all right?
I hear you, sir.
All right. Do we have a jury trial date on this?
March 17th.
All right. We'll set this is set for jury trial on March 17th at 9 a.m. Ms. Tubbs, did you want to discuss settlement with the prosecutor, or do you just want to go ahead to jury trial?
I wanted to ask the prosecutor a few things, if you don't mind.
Okay.
Your Honor, I would, one of the things I think that we put on the record last week when we were trying to establish whether Ms. Tubbs was going to represent herself, if we were going to relieve the prior defense counsel of his obligations and then also get standby counsel. And I think that today was more of an update just to make sure everything was in order, but knowing that the trial.
And I have ruled that she can represent herself, haven't I?
Yes.
Okay, all right.
And that's why the other counsel was relieved and
Right, okay.
Ms. Patillo was put on as standby.
All right.
With that, I think that we had mentioned the possibility of having Ms. Tubbs be brought over here so that we can have discussions. Ms. Patillo is standby. I feel comfortable speaking to Ms. Tubbs as long as there's somebody else there. Even if they're not fully representing her, at least there's a third person. And I wouldn't mind speaking to her in person, but I think it's going to be easier if she's here, and I don't necessarily want her to say something on Zoom in open court that might affect her case when she's representing herself.
All right. We can do this one of two ways. Either can put all of you in a breakout room and let the three of you discuss things, or we can bring her here.
I would ask Ms. Tubbs what she would like to do.
Ms. Tubbs, what do you want to do? Do you want to go into a breakout room with the standby counsel and your and the prosecutor, or would you like to come here physically to talk with them?
I can do standby counsel. I mean, I can do not standby counsel, but I can talk to them in the break room since she's afraid of what I have to say, so the public would not hear.
So if I could interject, I apologize, Your Honor. Would I be able to, well, if Ms. Tubbs allows, would I be able to speak to her before she speaks to the
I don't allow.
That's an excellent idea. Ms. Tubbs, would you be willing to speak privately with Ms. Patella?
No, sir.
All right, Ms. Patel, I don't think I can order her to do that. So, Ms. Tubbs, as I told you before, we got taught the first day of law school, he or she who represents themselves as a fool for a client. I would strongly recommend that you talk to Ms. Patella, but if you don't want to, you don't have to. What would you like to do with that?
With all due respect, sir, I am not working alone. I work with the Holy Spirit, so only a fool would think that the Holy Spirit ain't helping me. Not being smart.
All right, and I'm not being smart with you either. I'm telling you what they told us in law school, all right?
That's understandable.
All right, that's fine, Ms. Tubbs. So she apparently, will you be willing to have Ms. Patella in the room with you and the prosecutor?
Sir, I do not need her. Thank you.
All right.
I want somebody.
Yeah.
Regardless
so the
of who it
prosecutor
is.
says she does not feel comfortable talking directly with you without somebody else in the room. So
you're forcing me. You're forcing
I'm
me
not
to have.
forcing you to do anything. You know, you don't have to talk to him. We can just go ahead and have a jury trial. That's fine with me. So what the prosecutor is saying is if she wants to talk alone with you, that there has to be somebody else in the courtroom or in the room. So you tell me.
She can have her in the courtroom, but not on my behalf. It can be on her behalf since she's fearing what I have to say alone. I'm not understanding why.
Put the three of you in a breakout room to discuss things.
Okay, thank you.
Do you agree to that, Ms. Tubbs?
I agree to speak with her with the third party on her side.
All right. And counsel, how long do you think we should put you in the breakout room for?
10 minutes to be safe.
10 minutes, and then you can have more time if you need it, okay?
Okay.
Okay, thank you.
I'll take 5 minutes.
Okay, well, I'm gonna put you in 10. You can always stop early, okay?
Thank you.
Is there anything else we need to take care of before we send you into the room with Miss Tubbs? Is there any other matters that are ready? Madam Clerk?
Yes, we can take care of Mr. Kehoe.
Well, you know what?
Here this morning.
You know what? It's too complicated. Let's let them do this.
Okay.
Can you come into the breakout into?
Yeah, I'm gonna go into the conference room and log into Zoom.
Okay, all right.
People of the state of Michigan. People of the state of Michigan is the people on the benches. It's us versus us. This is sad. Oh, I pray we wake up.
Let's go back on the record with regard to Miss Tubbs' case. All right, let's call Miss Tubbs' case, please.
Calling case 2400390201. The people of the state of Michigan versus Tenia Nicole Tubbs. This matter is scheduled today for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
And good morning, Judge Deon Patillo, PA2378, stand-in counsel for Miss Tenia Tubbs.
All right, Miss Tubbs, if you can unmute and state your name for the record, please. All right, you can speak now. I think it's
You can hear
unmuted,
me?
ma'am.
You
Yep,
can hear
I can
me?
hear you. Yep.
For the record, I am Tenia Nicole Tubbs, the beneficiary of the account.
All right, Ms. Tubbs, you have a constitutional right to be physically present for this hearing. You agree to waive that right for today and hold this hearing by Zoom.
Correct.
Okay, all right, where are we at on Ms. Tubbs' case, Madam Prosecutor?
Your Honor, I did get some information from Ms. Tubbs and I did look up I know that the defendant is in Calhoun County Jail right now and that she has a sentencing date of March 24th, 2025. When is our trial date? The 17th?
March 17th.
I'm guessing that Calhoun County would let her come here pending their sentence, since we have a trial date. I don't know how that all works because their case is a 2022 case, so it's definitely older. But either way, that's a problem for somebody else, I suppose. I think that Miss Tubbs needs to be brought over here and maybe we should have a pretrial before the trial once Miss Tubbs is here, where we're all in person. And Miss Tubbs can bring whatever documentation that she wishes to provide at that point. That way we all have it, and we're all on the same page, because some of the things that she's referring to, I do not have. And I would say that we're likely going to have to proceed to trial.
All right. When are you proposing that we have this, bring her over beforehand? Obviously, the closer to the date for the court's purposes, the better, because we don't have to retain her as long from Calhoun. But if you think it would help to bring her earlier, we can do that too.
I think that approximately 2 weeks before, so that puts us in the March 3rd area. Sometime at the end of the week before or early the week of March 3rd.
I'm available the 6th, if that works for the court prosecutor and Ms. Tubbs.
All right, why don't we schedule this to have her brought over here for March the 6th, and we'll have the hearing at 11:30. Is that time okay for you, Attorney Patella?
Yes, Your Honor.
All right, we'll set this for March 6th at 11:30. Hey, May, can you send a writ to have her brought from Calhoun County here?
Yeah.
Okay, all right.
Excuse me, Your Honor.
Yes, go right ahead, man, Ms. Tubbs.
I am looking forward to being out of here before then, and it is my duty to come there on my own as a freeborn sovereign. to this. I do not need to be detained or retained. I am not an entity or subject to any entity. And I gave this paperwork to the 36th district. And I'm not gonna be able to get this paperwork if I don't be able to walk and go get it, go home and print it out myself, because I have none but 8 children. I am by myself. I don't have support. I just have myself and my 8 children, which my oldest just went to prison, so he's not able to help me any longer.
All right, well, we'll see you on March 6th at 11:30. You have a nice day, ma'am, okay?
So there is no holds on me, correct?
Well, you're gonna be in the jail here, Wayne County Jail.
What I'm telling you is that I'm gonna be released from here either today, tomorrow, and I do not need any holds to come to another jail. I am a freeborn sovereign. I do not need to be detained or retained. I am not subject to any entity or am I entity. I am a living being.
All right, you have a nice day, ma'am.
Well, guys, we've come to the end of this second appearance for Miss Tenia Tubbs. And I must say, I feel, a little bad for a couple of different reasons. But I'll say this, one thing, that sometimes is kind of unfortunate and it's hard to understand, but I guess it shouldn't be hard to understand, because obviously with the sovereign citizens, they're in their own world, they're believing, their own lies, own script, whatever have you. But, sometimes to see them not understand how beneficial standby counsel can be for them, because you're still representing yourself. But if you run into a snag, you can ask this individual, like, listen, what should I do here? Or what can I do here? And a lot of times, you'll see them, they don't allow themselves to benefit from that. And I think it's because they feel like these attorneys are also a part of whatever conspiracy is against them, or whatever it is that the court is trying to do to them. Like, even when you look at Miss Tubbs, when you think about it, when they were trying to do the breakout room with her, the prosecutor, and the standby counsel, in her mind, she was processing it as the prosecutor wanted to hide something that she had to say that she didn't want the public to hear, because it would be exposing the prosecutors. Because she kept saying, oh, she's scared, because she's scared of what I have to say, she wanted to go into this private room, not processing and understanding, like, no, we're going into this private room to protect, your business and protect, what it is that we're going to talk about when it comes to your case. And the standby counsel being there, it's just kind of like a referee to make sure the prosecutor don't say anything crazy and she doesn't say anything crazy. But for her to take that as like almost like a conspiracy type situation, it just goes to show where a lot of, these different sovereign citizens' minds are. And also, it was just kind of hard for me to hear that she has 8 children. Obviously, we all got to be held accountable for our actions. So, that's what she's going through right now. And unfortunately, her oldest son, she says, is in jail. And, probably because she's going through her situations, and I don't know what their household is like or where they live. But obviously, if she's dealing with jail and not really there with him, and the environment is about that type of lifestyle or those type of lifestyles, then more than likely that's why he's following down that path. So I'm hoping that, once this goes to trial and everything, that it gets squared away, she gets out and gets her life together. But we'll see. We're going to definitely keep following this case for you guys and keep you updated on it. And with that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. God bless you. Thank you for joining me. See you on the next proceeding.
Michigan versus Tenia Nicole Tubbs. This matter is scheduled for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
Good morning, Judge Dion Patillo, P82378, appearing as standing counsel for Miss Tenia Tubbs. Can you state your
Ms.
name?
Tubbs, could you state your name for the record?
Grand Rising, I would like to welcome the Holy Spirit in here. I would like to thank the Holy Spirit, and I would like to bring peace, joy, justice to this courtroom, as well as liberty. I am the beneficiary, the principal and equitable title holder, Tenia Nicole Tubbs. beneficiary.
All right. Ms. Tubbs, the person that's standing next to you is your by attorney. You can ask her any questions at any point in time. You're going to be representing yourself, but she will be here to answer any of your questions. Did you want an opportunity before we get going here to talk with her? Would you like to talk privately with her before we get started?
At this time, I would like to, I could talk to her for a second.
Right. Why don't we just send her back there? And then I don't know if you're going to have any, as the prosecutor, if you had a chance to talk with the standby attorney, or how do you want to do that?
I wanted to talk to the prosecutor.
Right.
Yes.
So I'm going to send her back and let them talk. Then do you, how do you want to handle that, Madam Prosecutor? Once she's met with her attorney.
However, I don't know whatever the court prefers. I mean, I'm happy to talk with all three of us together.
I guess if any offers, you can just put it on the record in court, huh?
Yeah, and I think that before we even get to there was no offer in this case. They were waiting on a mitigation package, and obviously because of how the competency has gone and the new attorney, and then Miss Tubbs representing herself, like there was no mitigation package. I could obviously go and get an offer, but before going that far, I want to know, speaking with the defense counsel and Miss Tubbs, where.
Right. Why don't you talk with Miss Tubbs, kind of figure out what way you guys want, what way she wants to go, and then we'll talk more, okay?
I want to dismiss this.
Okay, well, you talk with your attorney, okay?
I'm not having an attorney.
I'm not your attorney, but your
Okay.
standby counsel.
Okay.
P 82378 on behalf or stand-in counsel for Miss Tenia Tubbs.
Grand Rising, I would like to welcome the Holy Spirit into this place and thank the Holy Spirit to touch each and every last one of us, bringing joy, peace, liberty, and justice. I am the principal and equitable title holder, the beneficiary Tenia Nicole Tubbs, reserving all rights under UCC 1-207 and UCC 1-308.
All right, counsel, where are we at on this matter?
So what we discussed was Ms. Tubbs stated that she didn't have all the discovery, so the prosecutor went and printed all of the discovery. In terms of digital discovery, since Ms. Tubbs will still be in the Wayne County Jail until the trial, I'll put it on a flash drive and take it to the jail.
Okay.
She just would need a laptop.
All right, you want me to order a laptop for her?
Yes.
All right, then I'll order that Ms. Tubbs is to receive a laptop from the jail. All right, any other matters we need to take on?
The only thing I would like to indicate for the record, Judge, is that I am right now, the only thing that I didn't include in the discovery, I realized as I got down here that I didn't print the witness list. So I'm going to send that to the court and ask if Marita would be so kind to print just the copy of the witness list off. I will say that as far as paper discovery goes, I have included the felony information with all of the charges, the investigator's report, which is 3 pages, the reports from the police officers, which are 13 pages, the defendant's statement, which is a 3-page document, the Center for Forensic Psychiatry report that pertains to our case because we did not get any of the other ones from Calhoun County. The notice of insanity defense that the prior attorney Glenn had filed. And with regard to the preliminary exam, I did check, it was waived, bound over, so there is no.
You requested that be terminated, correct? That request for insanity defense? Do you don't want it, do you want an insanity defense?
No.
Okay.
I just wanted to make sure that I provided a copy of it.
I make sure we have an order that she has requested the withdrawal of an insanity defense. I think we already did that, but if we didn't, we need to sign that today.
Okay, and right now, your court clerk did print off the witness list for me. So I'm adding that on the discovery, and it is 1 page, Your Honor. And then I've put all of the discovery together, the paper discovery together in a white envelope that the defendant will be able to take back with her and have a physical copy for herself.
All right, can we give all of that to her right now?
Yes, I am.
I have a request.
Ms. Tubbs would like to address the court.
All right, Ms. Tubbs, you're receiving all that documentation, correct, ma'am?
And these are the.
Wait, no, we're
Yes.
not gonna, we're gonna do
Yes,
this one
I'm
at a time.
receiving the
Ms.
discovery
Tubbs,
package.
have you received all the discovery she just said?
Everything but what she said, the witness list.
All right, it's my understanding you gave her the witness list too, correct, counsel?
Yes, I added the witness list.
Also the injured party.
It's in the discovery. You just gotta read.
All right, so you have the witness list. You agree to that, ma'am?
Yes,
And you have all the other discovery, correct?
as of what she gave me, yes.
Okay, what else? What else, ma'am?
The digital, but I'm gonna provide that.
You're gonna provide that, okay, we'll get, all right. Anything else?
Besides, I would like to approach the bench.
Well, you can speak from there.
I can speak from here.
Yeah,
All
okay.
right, thank you.
Yeah,
I'm asking for this court to dismiss this case on behalf of the facts that this is a Nisi Prius courtroom. This also goes by equity, which also has no jurisdiction over me. I am not an entity, nor am I subject to an entity. And I have given all my rights that been infringed, which this goes by the Constitution, correct? And this goes by equity, correct? So by that being said, my rights was infringed. I have the right to bear arms and I have the right to travel. And that's
anything
why,
else? Yeah, your motion to dismiss, Stacy, anything else?
that's my motion to dismiss. You
Okay.
also gave,
Well, is there anything else with your motion to dismiss? I need to rule on that once you're done.
yes,
Anything else on the motion to dismiss?
yes.
Okay, go ahead, man.
My due process has been violated, right for
Okay.
life and liberty. The 180-day rule has been violated. There is no crime. If there is no injured party, I'm the only injured party. And that will be all. Besides, I reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement.
Okay, anything else with regard to your motion to dismiss?
I'm just asking for a motion to dismiss.
Okay, there is absolutely no basis in law with regard to your motion to dismiss. I deny it. Anything else we need to take up, ma'am?
So the only other thing was the documents that we were speaking of when we
Yeah.
were on Zoom. Ms. Tubbs did obtain those and she just wants me to give them to the prosecutor.
Okay, I have no idea what documents you're talking about, but
It's the bill of complaint and equity, presentment to void proceedings and jurisdiction.
And also my
Yeah.
affidavit of truth.
And yes,
It's on the other day. In my Sesta Q trust, because this is accordingly
I'm gonna
to.
need you to speak up, ma'am. It's a big room. Thank
Also,
you.
it's for my Sesta Q trust. I am the beneficiary over the trust account. You guys are acting as a.
Well, that really has
fiduciary,
nothing to
correct?
do with this courtroom,
It
but
really
anything
does.
else, ma'am?
It does,
Anything else?
but you can say that.
All
No,
right. Have you discussed potential resolution of this, Madam Prosecutor?
Your Honor, I have not talked to the Ms. Tubbs today, and the last I heard prior to her going off the record is that all she wants is the case dismissed. I don't know that there is a resolution that Ms. Tubbs would be amenable to. And the last time I spoke with her, when we were on Zoom, she indicated that the only thing she is seeking is a dismissal, which the people are
Well, I've
not.
denied that dismissal. We're scheduled for trial on March 17th. I don't accept pleas on the day of trial. Do you want to discuss resolving this matter with the prosecutor, or do you just want to come here March 17th at 9 o'clock for a jury
I would
trial?
like to discuss some resolutions.
All right.
The only thing that I can think of, Judge, in talking to your deputies is if the court wanted to turn.
You know, we're gonna do this in here.
Okay, that's what I was going to say.
And I'm gonna ask everybody to step out of the courtroom other than Ms. Tubbs, her attorney and you.
Okay.
And I'm gonna turn off Zoom and that type of thing, and then let you discuss that. But I'm gonna ask everybody to please step out of the courtroom. And we'll reconvene once they're done discussing everything.
Case 2400390201, the people of the state of Michigan versus Tenia Nicole Tubbs. This matter is scheduled today for a pretrial. Appearances for the record.
Good afternoon, Your Honor. Elena Rozek on behalf of the people, P78815.
Good afternoon, Judge Zion Patillo, P82378, standby counsel for Ms. Tenia Tubbs.
Great afternoon. Coming in as the principal and beneficial equitable title holder, Tenia Nicole Tubbs, beneficiary, natural living being. Coming in UCC 1-207, UCC 1-308.
Counsel, where are we at on these matters?
Your Honor, I believe that this is going to go to trial on March 17th. We did have an opportunity once the court excused itself and gave the courtroom to us to review some of the digital discovery with the defendant. Not all of it. There is 5 different videos, 3 police officer body worn cameras, 2 scout car videos. One of them is of the front of the scout car looking out. The other one would be for the back seat of the scout car. We have not gone through every single one of them, but we went through 2 different angles of body cams and that covered the incident that the defendant is charged for. She and I have a disagreement on what the actions were and what the facts are, and therefore that's what a jury trial is for.
Okay. Can you put on the record what the offer is, what the sentencing guidelines call for, and what you're going to recommend as far as a sentence, just so Ms. Tubbs understands everything?
Let me just double check really fast.
Okay.
It's long.
She says she's not in. On Zoom.
Oh, I see.
Okay, Your Honor, with the guidelines, 35. The guidelines as charged, if the defendant were convicted of 1 count of carrying concealed weapon, 1 and 2 counts of resisting and obstructing a police officer, and the habitual second offense notice, the guidelines would be 7 to 28 months to a maximum of 7.5 years.
Is she habitual?
Yes, a habitual second offense.
Okay, what's your offer?
The offer in this case, Your Honor, this is what I explained to the defendant also, is that there was a no reduced plea on this initially, and that the supervisors were asking for a mitigation package. Given the history of this case, there was no mitigation package that was submitted. The only thing that I could do at this point would be to ask the supervisors to consider something without the mitigation package and explain the history of the case and whatnot on my own. But I don't, in my conversations with the defendant, I don't know that that is, I don't know where that would get us.
Okay. And what are you gonna be recommending if you, if she were found guilty at the time of trial?
Your Honor, it depends, but I would say somewhere in the realm of 2 years in the Michigan Department of Corrections, up to with a tail of 7.5 years with the habitual.
And ma'am, the court is no longer bound by sentencing guidelines. I could give you a sentence less than the sentencing guidelines. I could give you a sentence within the sentencing guidelines, or I could give even more than 28 months, which is 2 years and 4 months. Understanding that, would you like to talk with your attorney about seeing if you can get some type of an offer that you'd be agreeable to, or do you want to go ahead and do a jury trial?
I tried to find out what the offer was. She said she didn't have one.
All right. What kind of offer are you looking for me?
I really want a dismissal, but the
Okay,
only offer
not getting
that,
a dismissal, we're beyond that, so.
okay, I get that.
Okay,
Well, the only offer I can see is because I'm not a habitual. I've never been in trouble with
Well,
them.
she said you're a habitual second.
I never had a gun charge. I've never
Well, I
had.
don't know about a gun, but a felony conviction?
I'm-
It's,
If
December
somebody says she's a
13th.
Habitual second, what is it?
December 13th, 2013, fleeing and eluding in the 3rd degree in Calhoun County. It says that you were convicted.
How does Calhoun County have anything to do with Wayne County?
State of
It's the
Michigan.
state of Michigan. Okay, well, that charge was dropped, correct?
Well, it sounds like you were found guilty of something. You must either pled or had a jury
I was
trial.
dropped. That charge got dropped. From my recollections, that charge was dropped.
Well, they're saying that it's not.
Okay.
So anyway, tell me what, if anything, you want the prosecutor to go and see about getting. What type of offer would you be willing to take, ma'am?
If anything, probation,
Okay. All right, let me talk.
and no
to
jail
both of you.
time,
I'm sorry?
no jail time and probation. I'm sorry.
All right, let me talk about the attorney.
I do have
okay?
8 children.
I'm sorry, what?
I'm sorry, I do have 8 children, and I've been away from them already 7 months.
All right, so let's speak. Let me talk to both of you.
Well, guys, we have come to the end of all 3 of these proceedings. And as we can see in this 3rd proceeding, which is going to be the only one that I'm going to do commentary on, being that you saw the commentary for the other 2, is that she definitely still has her sovereign citizen head on. But what I will say is, this is the first time I've seen her warm up this much to allowing her standby counsel to help her out, which is a great thing, which is a good thing. And we see that the prosecutor was saying, listen, we can take this to trial, but if it goes to trial, and she loses, I'm going to ask that the court, sentences her from anywhere from 2 years to 7.5 years. And as we can see with Judge Slavens, and, it seems like even with the prosecutor, Miss Tubbs, she isn't, a nasty person, talking crazy or being disrespectful. They seem like they want to help her. She has the 8 children, and we see in one of her previous appearances, I think she said her oldest son was in prison or in jail himself. So we see them take a break to see if they could figure something out when it comes to Miss Tubbs' case. But what happens is when it was time to come back on Zoom, they didn't. They just cut it. Once they figured out whatever they were going to do, they just cut it. So I had to go and look up her case and find out what happened. And guess what, guys? Miss Tenia Nicole Tubbs pled guilty. As you can probably see on the screen now, she pled guilty to all 3 charges, the weapon charges, and also the 2 police officers, the interfering, the obstructing, and the assaulting on the 2 officers. She pled guilty to that as well. But her sentencing won't be until March 21st. So we won't know what she will get sentenced to until March 21st. But, hopefully it'll be something she can manage and get back to her children and hopefully do the right thing afterwards, being that they, wanted to help her out, and seems like they got to her and, talked her into not going to trial and messing around and probably doing some years and really missing out on her kids' lives. But we'll see. We'll follow up on this. We'll see on March 21st if they air the sentencing, because sometimes some courts do, some courts don't. But at least we'll be able to punch up her case and see the ultimate outcome of this whole entire thing. But with that being said, I know that commentary was a little long at the end, but I wanted to show you guys that and explain that to you guys. But thank you as always for joining me for these proceedings. This is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. Don't forget to subscribe, like, and share. It helps us out a lot. Until the next time, guys, God bless.
Hello, sir.
How you doing?
I'm good, thank you. What's your name, sir?
If I can help you.
I'm Williams L.
Yes, Your Honor, but the defendant is identified in the docket as Michael Williams. Is that correct, sir?
Yes, that's the name they're calling me, but I am Williams L.
I understand.
Michael Williams. Okay.
No,
Mr.
I'm not
Williams,
Michael Williams, Your Honor.
Okay.
I am Williams
Okay.
L.
Okay. So here's the thing, Williams L. I have to call you what's on the documents that I have present for me in court today. We can either handle it that way, or you don't have to handle it, and then it just will be like you didn't show up to court today.
No,
So it's
Your
either
Honor,
way,
I'm just
but I
letting
have
you
to
know
call
who
you.
I. Your Honor, I'm just letting you know who I am.
Okay.
I am Williams
That's fine.
L. I am not Michael Williams. They kept calling me Michael Williams. I told them who I was. I am a sovereign, Moorish American. I'm not United States citizen, Negro, Black, or color, Your Honor.
Okay, so let me tell you, Mr. Williams, this is the last time I'm gonna say it. This is all I have for you. If you don't want to handle it under that name today, then I have to act as if you aren't present. And so that's fine, but I
You
have
say
to
what?
call
Hold
you
on.
to that
Can you
document,
can you repeat that? Can you repeat that,
I
Your Honor?
said, if we can't handle those matters and those tickets that's on that case under that name, then that's fine. But it's gonna be as if you didn't appear for court today, because I have.
Ma'am, I'm here today, ma'am.
Right, so I'm just saying, when I.
Williams
call those
L is here
documents,
today. I'm
Did
just
you-
letting you know
Hold
who
on,
I
Mr.
am,
Williams.
ma'am. Yes, I do.
Okay.
I am Williams
Okay.
L.
So that's fine. When I call it on the record, I'm gonna have to call it on the record as the name on the ticket, just so you know, okay?
Okay, and I'm gonna let you know that I'm Williams L. Okay, I'm cool
That's
with
fine.
that. And I'm letting you know who I am. I'm a
Okay.
Moorish American.
Okay, did you wanna
Sovereign.
offer? Okay, did you wanna offer for it or no? Are you gonna try and I need to kind of know where you're going. Are you gonna want a trial? Are you gonna try and wanna offer?
No, I do not agree. I do not agree to none of this. I'm sovereign.
Okay, so if you're not gonna participate, we're just gonna act like you're not here today, and I'm going to go ahead and.
I am here today, ma'am. You seeing me right here? That's on
You
record.
have to- Listen, just because you show up doesn't mean that you're here. You have to participate, okay?
Ma'am, I'm a sovereign. I'm letting you know who I am.
Listen,
I'm participating. I do not agree.
Mr. Williams, that's fine, but if you don't participate, saying you're a sovereign doesn't help me.
I'm just letting you know who I am. That's
Okay.
violating a constitutional right, ma'am.
So do you want an offer or not? That's my question.
Do I want to what?
An offer to the tickets or not?
Do I want to? I can't understand. You said, do I want to offer
Do you want an
tickets?
offer? Do you want to try and resolve this today as far as?
Yes,
the offer?
I do want to resolve it. I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
Oh, no, that's not gonna happen. So you can, I'm
Well,
not gonna.
I'm
dismiss
just,
it.
I'm speaking for myself. I have no attorney, so I'm speaking for myself. I asked for this
Okay, I'm
case to
calling
be
that Tenia
dismissed.
case.
Violated my constitutional right.
How
And
do you
I
have
asked for your
constitutional
oath of
rights if you're not a citizen?
I'm not a United States citizen.
So how are you entitled to constitutional rights of citizens?
You got to uphold to the sovereign, sir. You can't. I'm not United States citizen. I'm not Negro, Black, or color. You're not under I'm not under your jurisdiction.
I understand, but my question to you is, if you want to rely on your constitutional rights, how do you have constitutional rights if you're denying your citizenship?
Because I'm an American. I'm a
I
national.
I get
I'm
it,
a
but
Moorish American. I'm not United States citizen corporate. I'm a Moorish American. I'm an American national.
okay, but you're still present in this jurisdiction, right?
I just asked for this case to be dismissed off lack of jurisdiction. That's it. I don't want no attorney. I can speak for myself. I'm not a minority. What am I doing here?
He can represent himself. Don't worry about it. You put
I can
yourself on.
speak for myself.
All right.
I'm speaking
Now
for
calling the
myself.
matters
Y'all
of the
violating my
people.
rights. That's a
Now
sovereign.
calling the matters of the people versus Michael Williams. This is ticket number SP 12123334. Count 1, use loudspeaker without permission or unreasonable noise. Count 2, drove while license suspended. Count 3, no insurance misdemeanor. Sir, please state your name for the record.
I am Williams L.
All right. Sir,
I don't have a name. I have a title.
This is the date and time set for an arraignment on a bench warrant. Do you want to participate in these proceedings?
Yes, I'm here on special appearance. I'm just letting you know who I am.
All right, so how would you like to move forward with this matter, sir?
I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
All right, that motion has been denied. How would you like to move forward on these matters?
I just told you what I would like it, so I don't know. I'm just here on
So it's
special
been
appearance.
denied, so you can either participate today.
I am participating. I'm here.
No.
I'm speaking for myself. I have no attorney, so I'm just letting you know. It's denied, so we can keep going on with proceedings. I am Williams L. I'm not a United States citizen. I'm not Negro, Black, or color. I'm not Christian.
All right, Mr. Williams, it appears to the court as I'm making a record that he does not want to participate in these proceedings.
I told you I
like
wanted to participate. I'm just letting you know who I am. I told you for the record.
All right, he would like to not participate in these proceedings. He has told me that he is the person known as Williams L. and not the person on these tickets, so he is not appearing on behalf of this person. This person has not made themselves available to the court today as an arraignment on the bench warrant, so these matters will stay in warrant status. Thank you so much. That concludes this hearing. Have a good day, Mr. L. Williams.
Williams L.
Williams L. I'm gonna call the case as is.
Okay.
And then I'll refer to you as Williams L. if you would like, okay? Now calling the matters of the people versus Michael Williams, also known as Williams L. This is ticket number SP 12123334. Count 1, use loudspeaker without permission or unreasonable noise. Count 2, drove while license suspended. And count 3 is no insurance misdemeanor. Sir, can you state your name for the record, please?
Williams L.
Okay. And is there another name that you have?
That's not my name. That's just my title.
Okay. What's your title that you have, sir?
Williams L.
And then is that your name or your title?
My title.
Okay. You don't have a name at all?
No, I'm not Christian.
All right. It's my understanding that you don't want to have an attorney, sir. Is that correct?
Yes, sir.
Now, you know you have the right to have an attorney. These matters are misdemeanor matters, and you have the right to have an attorney on these matters, sir. And it's my understanding, no attorney, okay? So let me advise you of your rights. In these particular matters, the court can, since they are misdemeanors, do either, I think, 90 days on one of these and up to 93 days in jail, or a maximum fine of $500. These are all misdemeanors, so that's the maximum penalty that can be given in any of these matters. You have a right to have a trial, a bench, or a jury trial in any of these matters. A bench trial is a trial before myself as the trier and finder of facts. A jury trial is a trial with 6 members of the city of Detroit who will come in here and hear the same information and make a decision based on that. These are your rights that you have right now. You also have a right to have a pretrial. What that does is that gives you time to think about any offer that may be given to you. At this point in time, there has been an offer extended to you that if you are willing to plead to the no insurance misdemeanor, it will be reduced to an improper place. I set the fine that goes with that. You have a right to, you can also move for a motion. If you know how to file those, you can file a motion as well. So what's your pleasure at this time, sir?
I know I'm under common law. I'm not under statutes or codes or regulations.
So when you drive on any city street in the city of Detroit, any road in the state of Michigan, you now avail yourselves, whether you wanted to or not, to the laws and states and regulations that are governing us. So you may not have wanted to, but you did. So these are your options at this point in time. If you choose not to, if you were traveling, if you were driving, it's all the same.
I wasn't driving, I was never.
So If you were just in the vehicle as a passenger?
I was parked. And they was harassing. Was
You sure
never
you
driving.
don't want an attorney?
I'm under common law. I can speak for myself. I'm not a minority. I'm a sovereign.
So what option would you like today? Of those that I gave you, sir? You can have.
Ma'am, I'm a sovereign. I do not consent. I can't. I can't
So here's
consent.
what's gonna happen. So I want to make sure you have all the options. You can't consent to anything. So that means that you don't want to participate in the process. So it's just gonna go back into warrant status. Because you have to pick one of the options, yes.
Ma'am, I'm a sovereign.
And you were in the city of Detroit on a street in a vehicle. And I understand what you just said. That's why I said,
right.
did you want counsel?
I'm not a United States citizen. Nobody have improved jurisdiction. I'm under common law. Statutes don't apply to me. I'm under common law. Supreme Court case, Supreme Court case, Self versus Ray. Statutes don't apply to me. I'm on common law. And if there was a crime committed, can you please show me the injured party? Or I ask for this case to be dismissed off lack of jurisdiction.
I deny the motion for the case to be dismissed. So you have these options, or else it's just gonna remain.
And I'm under duress because you forcing me saying you're gonna put a warrant out for my arrest.
It's already out there.
But that's violating my 13th Amendment. You can't enslave me unless a crime has been committed.
So you can't.
You can't violate my constitutional
Let me
rights.
finish talking. You can't claim you're sovereign and then claim rights under the Constitution. That's not how it works. No, that is not how it works.
I'm not a United States citizen. I have a nationality.
Okay, so that means that
you have to go by
either the laws all apply or none of them apply.
The laws do apply. What do you have a liability? Do you have a bond? Did you swear oath to the Constitution? I would like to see that.
Yes, I was about to say I did do that, but I don't have to show you any of that because I wasn't the arresting party. I'm just here to make sure.
Do you have a liability? Do you have a bond?
Listen, I'm not going to argue with you, Mr.
I'm not arguing. I'm under law.
Mr. Williams L. Those are your options. If you don't want any of those options, it's going to remain in warrant status.
You're forcing me. You can't do that.
Okay.
You can't do that, man. You can't go against Constitution.
Okay, Mr.
You took an oath. You swore an oath to follow the Constitution.
I did.
That's why I need your liability bond. Do you have a liability bond?
No.
You don't have a liability bond?
No.
Wow, man. Somebody's going to get in trouble. I'm not trying to get nobody in trouble.
Yep. Okay.
Okay.
Mr. Williams L., I was about to say, if you don't want any of those options, then your only other option is that I have to leave it in warrant status.
I do not consent. I'm here. What warrant? That I didn't show up?
That you didn't want to choose one of these things?
I don't have to. You can't force me to do that, all right?
You're right.
You can't force me. You can't put a warrant out. I would like to talk to somebody, a chief judge. You're violating my constitutional rights.
You can go to the fifth floor and make a complaint.
Yes, because you're violating my constitutional rights.
All right.
And I'm going to ask the sheriff for your liability bond.
Okay.
Hey, I don't want to do that.
Okay, you can ask him. Go ahead and ask the sheriff for my liability bond. It's fine.
Took an oath to swear to the Constitution. You took an oath. I'm under common law. I'm not under statutes or regulations.
Okay. Thank you, Mr. Did you get all that, Ms. Sandy? Okay, fantastic. All right, that concludes this hearing. Thank you so much.
I'm not Negro, black, or color for the record.
Okay. He said he's not black or color for the record either, okay?
No, I'm Moorish American. I'm a Moorish.
Moorish American, and he's a sovereign.
I have a nationality.
Well, guys, we have come to the end of these proceedings. And as we can see with Judge Taylor and Mr. Michael Williams, or as he likes to be referred to as Williams L., pretty much same sovereign citizen lingo we hear all the time. I mean, I don't know how many times he said, ma'am, I am a sovereign. I'm just letting you know. I mean, he repeated that over and over again. But let me say this, because I want to give respect where respect is due. If you follow this channel, we have had Judge Marlena Taylor on the channel in the past, and many of you were not happy with how she handled the situation with Timothy Williams some time ago. I don't know what's going on with these William boys, but maybe she deals with all the W's in the courthouse. I don't know. But if you guys remember Judge Taylor and the Timothy Williams situation, it was a multiple appearance proceedings, and I will leave a link in the description to those proceedings for you guys that want to see it. But some of you felt like she let Mr. Williams go on too long, Mr. Timothy Williams, to the point of where some people felt she almost had a little crush on him or liked something about him. But respect to her, because she was not having it today. I don't know if somebody got on her neck about what happened in the past or how she handled sovereign citizens in the past. But today, both proceedings, she was not having it. So shouts out to her for standing firm and being firm. And who knows, maybe she did take a liking to Mr. Timothy Williams, saw something in him, wanted to help him out, wanted to be patient with him. But this guy, she wasn't trying to hear it. And pretty much his second proceeding ended just like the first one did. And I dug into this. I did a little bit of background checking, and this situation is still open. I think he has a bunch of failure to appear. So if anything else pops up dealing with this case, I will share it with you guys. But for now, this is where we are. The case is still open. Nothing's been resolved, and Miss Judge Taylor is not having it. So thank you guys once again for joining me for another Sovereign Citizens Hall of Fame. And with that being said, guys, this is Sovereign Citizens Court. And for now, court is adjourned. Talk to you guys soon. God bless.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on the Zoom? Say something if you're here at this time.
Yes, Your Honor. Javar Grayson representing myself.
All right, thank you, Mr. Grayson. Good morning to you as
Good morning.
well. So, all right, I see that there is the, let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You telling me that the court doesn't have jurisdiction, and you're not sitting into the jurisdiction of the court. Then why are you filing something in this court if you believe the court doesn't have jurisdiction? You filed
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department, who's representing this police officer, filed its motion back in June. dismiss in lieu of an answer, so I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any of those grounds.
Well, certainly. Let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. No, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that the defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, straight that if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, no factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is some type of traffic ticket. I started off Brian Ambrosius stopping me, and I believe I have the right to travel. It started with that. And I do understand the default judgment, what that you are saying and what it's pertaining to. We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michael, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiff. It does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. disputing my birthright. I'm disputing my right to travel.
All right, I got it. All right, that you failed the state of action upon which the court can grant relief. This case and the complaint in this matter be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular file. Good day to both sides. I wish you well.
Well, guys, we have come to the end of this proceeding, and really not a whole lot of commentary needed on this one. As we can see, he came in. Judge Coleman pretty much raised the same question that Judge Perkins did when Judge Perkins found out that he was suing Corporal Ambrose. Judge Perkins said to him, as well as Judge Coleman, if you don't feel like the court that you're in currently with Judge Perkins has jurisdiction over you, why would you file a lawsuit here or try to sue the corporal here in this courtroom? Because they're both in the 36th district, even though they're different courts. You should feel the same about both, right? Like either one shouldn't have, if one doesn't have jurisdiction over you, the other one, you should feel the other one doesn't either. But, Judge Coleman asked him, what is this case about? And if you notice, he really couldn't even explain. And one of the main reasons why is just what Attorney Michael said. Listen, he's using this as a tactic to get out of tickets that he don't want to pay. He believes the officer shouldn't have touched him. If you watch the other, proceedings before Judge Perkins, if you haven't, I encourage you to go do so because you would understand a lot of this more. He just was coming up with all types of stuff to try to get out of the responsibility that he had for paying those tickets. But nonetheless, like I said, wasn't much commentary on this one. It ended like we all expected, especially all of us that know what was going on in Judge Perkins' court. We expected this outcome. So with that being said, this is Sovereign Citizens Hall of Fame, guys. I appreciate you guys joining me always. Just sitting in on these proceedings, checking out these videos. And with that being said, guys, this is Sovereign Citizens Court. And for now, Sovereign Citizens Court is adjourned. Don't forget to subscribe. I appreciate you guys. God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.